All right, I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Harris, Senator Dondale Loop, Senator Orenshaw, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you so much. Please mark those senators present who are not present yet when they arrive. We have two bills on for hearing this afternoon. Just so you all know, the game plan is to take AB 68 first. We already have our presenter here. I just got word that the Assembly has adjourned, so after AB 68, we'll roll right into AB 231. With that, I'll open up the hearing on AB 68.
Thank you, Madam Chair, members of the committee. I'm Patrick Cates, the Douglas County Manager. The bill before you today, AB 68, deals with the funding formulas for counties to support a regional facility for the treatment and rehabilitation of children. This section of statute only applies to one such facility in the state, and that is China Spring. China Spring is a camp operated by Douglas County, and we serve all the counties in the state with the exception of Clark County. It's a very critical component of the continuum of care for juvenile justice, and youth are sent there based on judges' orders. There are other facilities in the state that have similar programs. Clark County runs Spring Mountain, and the state runs Summit View, Caliente Youth Center, and Nevada Youth Training Center, just as a comparison. China Spring is regularly ranked as the highest ranked facility in the state by several metrics. It's a very good program, and it serves up to 56 youths at a time at full capacity. So the purpose of the bill is to address the funding formula. Most of the funding for the state comes from a combination of state appropriations as well as assessments on the participating counties. Under current law, the assessments are based on student population of each county. So depending on what that is, that determines each county's assessment. And I know on Nellis you have a spreadsheet that kind of shows the impacts on all the counties under the current law and what this bill does. During the interim last session, a working group was formed under NACO, and all the counties participated to look at a variety of aspects of China Spring and their programming and funding, and also to look at this funding formula. And we worked in the interim on something that was acceptable to all the counties, and that's what this bill represents. It was reviewed by that working group, and all the participants were in agreement. What it does is it bases the funding formula, it keeps some of it based on student population, but it also looks at utilization. So we would look at bed days from prior years and figure out utilization. Half of the rate would be assessed on that basis, the other half would be based on student population. And that was really impactful primarily to the small rural counties. We have some counties that may go a few years without sending a child to camp, but they were still paying assessments. So this way, because some of it is still population based, they're always going to have to pay something, but also what they pay is based on their utilization. So overall, the impact of that, the higher utilizers of the camp would tend to pay more. I know Douglas County would pay more under this formula, and we're good with that. The really small rurals would benefit financially, and I believe Washoe County's assessment would also go down. Of course, that could change from year to year depending on utilization. As I said, there was universal support from the 16 counties. There was no opposition in the Assembly for this bill, and I believe it was passed unanimously, and I'm happy to answer any questions.
All right, questions from members of the committee? I'm not seeing any. I just wanted to clarify, am I understanding correctly that some contributions will increase and some will decrease?
Correct.
Okay.
The overall contributions of the counties combined wouldn't change under this law.
All right. I Don't see any questions, so or other questions. So we will move to testimony in support of AB 68. Anybody wishing to give support testimony in person is invited to the front here in Carson City or down in Las Vegas. And we'll start in Carson City. You'll each have 2 minutes whenever you're ready.
Thank you, Madam Chair. For the record, my name is Vincent Guthrow. Last name is spelled Gutreau. First name is Vincent, Vinson. Serve as the Executive Director of NACO, which is referenced in the testimony, or the Nevada Association of Counties. We represent all 17 of Nevada's counties, and we thank you for the opportunity to provide testimony in support of Assembly Bill 68. As mentioned, this represents a collaborative agreement on the methodology to provide funding for the regional treatment and rehabilitation facility that is available to 16 of our counties in the state, and it reflects an equitable assessment and reflects usage of the facility, and we're in support of this measure. Thank you.
Thank you, Madam Chair, and members of the committee. For the record, Mary Walker, representing Douglas, Lyon, and Story counties. We do rise in support of AB 68. We believe this is much more fair and equitable. The current formula that's being used hasn't been changed in decades. Also, the China Spring Youth Camp is very, very important to rural Nevada because for many of these smaller rurals, this is the only juvenile facility that they have for service for their juveniles. Thank you.
Sure. It sounds like Senator Orenshaw has a question.
Thank you very much, Chair. Thank you, Ms. Walker. Just wonder, what is the capacity of the China Springs facility? Is it only boys or is it boys and girls? I just wonder if you have that information. If not, maybe I can get it offline.
Thank you. For the record, Mary Walker, it is both boys and girls. Because of the COVID as well as the state funding reduction that we've had the last couple of years, those counts have gone down, but we're planning on getting them back up. I think total capacity is about 60 kids.
Thank you. Thank you, Chair.
Thank you.
Thank you. All right. I don't see anybody else coming up to testify in person in support, so we will go to the phones for support testimony on AB 68.
If you would like to testify in support of AB 68, please press star 9 to take your place in the queue. We have no callers testifying in support.
All right, then we will move to testimony in opposition to AB 68. I don't see anybody coming up to give opposition testimony in person in Carson City or Las Vegas, so we'll go to the phones for opposition testimony on AB 68.
If you would like to testify in opposition of AB 68, please press star 9 to take your place in the queue. We have no callers testifying in opposition.
All right, then we'll go to neutral testimony on AB 68. Not seeing anybody coming up to the microphones in Carson City or Las Vegas, we'll go to phone testimony for neutral on AB 68.
If you would like to testify in neutral for AB 68, please press star 9 to take your place in the queue. We have no callers to testify in neutral.
All right. Unless you have any closing remarks, that will conclude our hearing on AB 68. The hearing's now closed. I will open up the hearing on AB 231.
Madam Chair, we are supposed to have someone, I think, on Zoom, and I just want to make sure they're on. Good afternoon, actually, Chair Scheibel and members of the Committee on Judiciary. For the record, I am Shay Backus, Assemblywoman for District 37. I am also a Nevada Commissioner to the National Conference of Commissioners on Uniform State Laws, often referred to as the Uniform Law Commission, or ULC. Today is my pleasure to introduce Assembly Bill 231 with Ben Orzeski, Legal Counsel for the Uniform Law Commission. Prior to walking this committee through the bill, I want to provide you with a brief history of the Uniform Law Commission. The ULC was established in 1892 to provide states with nonpartisan, well-conceived, and well-drafted legislation. ULC's deliberative and uniquely open drafting process draws on the expertise of commissioners, but also utilizes input from legal experts and advisors and observers representing the views of other legal organizations and interests that will be subject to the proposed law. ULC stays up to date by addressing important and timely legal issues, such as the need for an amendment to the Uniform Commercial Code to address emerging technologies, including adding a new article. Before I turn this over to Mr. Orzeski, I want to give a high level of the Uniform Commercial Code, commonly referred to as the UCC, so that you have an understanding as to what the bill is exactly amending. The UCC is a comprehensive set of laws governing all commercial transactions in the United States and has been universally adopted by all states. While parties to any particular transaction can agree to the terms of their contract, the UCC is essentially default rules and provides legal certainty, giving strangers confidence to conduct business. At this time, Nevada has enacted 10 UCC articles, which is codified in Chapters 104 and 104A. Article 1 provides general terms. Article 2 governs the sale of goods. Article 2A governs leases of personal property, such as construction equipment. Article 3 governs negotiable instruments, such as a check. Article 4 governs bank deposit and collections. Article 4A provides a comprehensive body of law on the rights and obligations connected with fund transfers. Article 5 governs letters of credit, which are typically issued by a bank or other financial institution to its business customers in order to facilitate trade. Article 7 covers documents of title to personal property, like such as bills of lading. Article 8 provides a modern legal structure for the system of holding securities through intermediaries. Article 9 provides a statutory framework that governs secured transactions involving personal property. At this time, I will turn this presentation of Assembly Bill 231 over to Mr. Orzeski, who will walk you through the sections of the proposed bill and also will be here to answer any questions that you may have. Before I do that, we also have another co-presenter who's unable to present today, which is Professor Raleigh. So if anyone has some remaining questions about the Uniform Commercial Code and what the emerging technologies does, he also will make himself available offline to answer any questions. So with that, I'll turn it over to you, Mr. Orzeski.
Thank you, Chair Scheibel and Assemblywoman Backus and members of the committee. Thank you for the opportunity to be here and testify in support of Assembly Bill 231. Which is an update to the Uniform Commercial Code, a law that has been in existence in the United States since the 1940s. And it's one that we don't often have to think about, but it's a very useful background law in the sense that when we order something as consumers from Amazon or eBay, we don't have to worry about what state the seller is in. It doesn't matter because the UCC has been enacted universally and will govern those transactions. Likewise, Nevada businesses benefit from being able to sell to customers in any state and knowing that those transactions are fully legal and enforceable because the state law governing them is the same. This is the first major update to the Uniform Commercial Code in 12 years, and it incorporates changes to deal with a lot of different technological advances. Some of them are mundane, where they're changing the word writing to record in a number of places to account for electronic documents and electronic signatures. Other amendments are more significant, the most significant being the addition of a new Article 12 to deal with something called controllable electronic records. And that is an umbrella term that's meant to encompass new types of property that include things like virtual currency and non-fungible tokens, things that exist on a blockchain and can be controlled over a computer network. The old rules, unsurprisingly perhaps, didn't apply well for transactions involving these new types of property. And so the new Article 12 on controllable electronic records is going to give some legal backing to transactions that involving these types of digital assets that didn't exist before. I'll touch on two major ones. The first is the concept of negotiability. So if you pay for, say, a cart full of groceries with either cash or a check, that's a negotiable instrument. And there's some safety in that for the merchant, for the grocer who sells you that cart full of groceries. It doesn't matter if later it turns out that that money turned out to be embezzled from the employer, from the buyer's employers, or borrowed from somebody else. The grocer is off the hook. The grocer, because it's a negotiable instrument, the grocer gave value in exchange. They didn't know of any other claim. They're an innocent party. And it's the buyer who is still on the hook for any loss of the person who lost that cash. Now turn around that example. For some reason, the grocer had accepted payment in a diamond ring. That's not negotiable. And so if it turns out later the diamond ring was stolen, then the person who it was stolen from can recover that, not only from the grocer, but from somebody who the grocer sold it to, and so on. This is just meant to illustrate the concept of negotiability. Right now, under the law, digital assets like virtual currency are not negotiable. And this is a big reason why more businesses don't accept them as payment. After enacting these changes into the UCC, they will be negotiable under the same terms as other types of negotiable instruments. That is, if the person gives value in exchange and doesn't have knowledge of any other claim to it. The other major advantage is one, using these types of assets as collateral. The rules in the UCC, the existing rules, didn't apply very well. If you wanted to borrow against your virtual currency, the rules for tangible currency dictate that for the lender to protect themselves, for the lender, if you default on the loan, for them to be able to collect on the collateral, they have to possess it, meaning they actually keep it in their safe, like a gold bar or something like that. And the concept of possession, as it's been interpreted by courts since the 1940s, doesn't apply well to intangible things that you can't hold in your hand. And so under the existing rules, the things like virtual currency fall into a catch-all category called general intangibles, and the loan rules didn't work very well for them. With these new rules for controllable electronic records, they will legalize the practices that are already developing in the decentralized finance industry, where lenders who do loan against this type of asset, they have what's called control of it. Essentially, they take what is equivalent to possession of a tangible asset. If you can control a digital asset like this, then you are protected. You are safe in the event of a default, and you can be sure you'll have collateral to collect on. So those are the two major advantages. I'm happy to take any questions, but what you have in front of you is the result of about 3.5 years of work with leading thinkers from not only the decentralized finance, the blockchain community, but commercial law lawyers, judges, and all members of the commission and the American Law Institute who worked on these. So thank you for your attention. I'm happy to take questions.
All right, members of the committee. Senator Orenshaw.
Thank you very much, Chair Scheibel. And it's more of a comment. I want to thank Assemblywoman Backus and our Legislative Counsel for the Uniform Law Commission, Ben Orzeski, and Professor Keith Rowley, and all of the other folks on the drafting committee for working on this. I believe the only reason I passed the Nevada bar exam is because there was no question that year on Uniform Commercial Code, secure transactions, and issues like that. So I'm no authority on this, but I know that great minds like Professor Rowley from Boyd Law School and all the other folks in the drafting committee worked very hard on trying to modernize the Uniform Commercial Code. It made such a difference almost a century ago in terms of trying to make transactions and negotiable instruments work across state lines, even if a bank or financial institution was only in one state, not like we have now across the country. Certainly there was no internet when the Uniform Commercial Code was first drafted by those attorneys who got together and tried to come up with this, and it got passed in all the states and territories. So I appreciate the modernization of the Uniform Commercial Code, and definitely want to thank Assemblyman Backus, and thank you, Chair, for hearing this bill.
All right. Any other questions from members of the committee? I just wanted to clarify one thing because we do hear numerous bills from the Uniform Law Commission, and it's my understanding that generally it is it's always an opt-in situation, and for a lot of what the Uniform Law Commission does, it's a kind of a patchwork across the United States who adopts it and who doesn't. But this particular bill relates to the Uniform Commercial Code, and I just want to confirm that all 50 states have adopted the Universal Commercial Code.
That's correct. The
Uniform.
UCC is one of our more success. It's
I
one of
meant
our
uniform,
more
not
successful
universal.
projects it's one of our more successful projects in that it's been adopted universally or across the United States anyway. The 50 states plus the District of Columbia, Puerto Rico, and the U.S. Virgin Islands have all adopted it.
And just to further clarify, there isn't another body that would meet and discuss the language of the Uniform Commercial Code. It would be the Uniform Law Commission.
The Uniform Commercial Code is a joint project of the Uniform Law Commission and the American Law Institute, and so it was a joint committee, a drafting committee of appointees from both of those organizations. There may be, other groups, academic groups and business groups that meet to discuss it, but they're not the official drafting committee who takes input and recommends the changes that were approved last summer by both the ULC and the ALI.
And if you could just put your name on the record again.
Sure, I'm sorry. Benjamin Orzeski. It's spelled Benjamin. Last name is Orzeske. Thank you.
And if I may, Shay Backus for the record, by and through Chair, in responding to Chair's inquiry, one thing I did also want to add is when we are doing these committee hearings on this, there are also members from the American Bar Association, like you would have someone from the business law section that would be appropriate, that would be sitting on the committee as well.
All right, thank you. I think we have one more question from Senator Krasner.
Thank you, Chair. Thank you for your presentation, Assemblywoman Backus. And sir, thank you for your Mr. Ozarski. Thank you. So,
Orzeski, yes.
how many states have adopted these amendments, these current amendments to the UCC?
So far, 2, North Dakota and New Mexico have adopted them. It's been introduced in another 24 jurisdictions, 23 states plus the District of Columbia, and those bills are, some are advancing, some are not going to pass this year. I don't know what the total count will be at the end of this year.
And follow up, please. And how many states have decided not to adopt these current amendments to the UCC?
Well, I don't know that any have made that decision permanently, but bills have failed this year in, I think, 8 or 9 states.
So 8 or 9 states, the bills have failed to adopt these amendments this session. That's correct?
Yes.
Okay, and
That's
so
correct.
what would happen if a state does not choose to adopt the amendments this session?
Well, they can always come back and try again, but they would the downside of that is that the businesses in the state would not. The businesses in the states that do adopt it would have a head start over businesses in the states that don't adopt it in implementing these new rules and doing business with the new forms of assets.
And if I may also add, Shay Backus for the record, by and through Chair Scheibel
You can go
to
direct.
Senator Krasner. One of the things was early on when these bills were initially presented in certain states, there was a lot of misunderstanding as to what the bill could or could not do. And with that, the Uniform Law Commission has made a real big effort to do an amendment to the pending uniform, the amendments to the UCC. And with that, on the Assembly side, we enacted those amendments. And so it addressed a lot of concerns that were being raised in other states. And you may get some emails now, but most of the concerns were addressed in an amendment that we did. And if you notice, this is the first reprint that incorporated the amendments to address some concerns.
Thank you very much. And then just one more. So my understanding is controlling law would first be federal law, then any state law on that subject, and then third would be the Uniform Commercial Code. Is that correct? It's backup law.
I can go ahead and answer that too. Oh. Shay Backus for the record, Senator Krasner. It would depend what we're looking at. And so if we were, if we were in federal court and there was a transaction between 2 states, usually I actually had a UCC case, which was on some construction equipment with like a leasing situation. And you still go to the choice of law aspects. And in that situation, the choice of law ended up, I lost. I wanted to make it in Idaho state law because that suited my needs for a statute of limitations argument. But in this situation, Nevada law was the law that was applied. So it's like your standard thing. And then this would be, I mean, I don't even know if this would be considered right now secondary authority, but it could be. But if we adopted this into Nevada law, like right now, our existing chapter 104 and 104A would be the applicable state law. And if we were to adopt this, that would amend those statutes.
Okay, and then if we chose not to adopt it or be one of the states that didn't adopt it this session, then applicable state law would apply still. It would have no bearing. Okay, thank you.
So I think maybe just to clarify, when we talk about amending the Uniform Commercial Code, in the context of this discussion, we're talking about amending Nevada revised statutes. There's not a separate body of law that exists. It's just a section of the NRS that we call the Uniform Commercial Code because it is the same as the revised statutes of Idaho or Washington or California or anywhere else.
Thank you, Chair, for that clarity. Shay Backus for the record. So right now, if you do open up, like in the Nevada revised statute tiles linked to 104, it's kind of weird because it only has all of the non-ending A articles, and you will see it like mirror the Uniform Commercial Code. You'll see like Article 1, you'll see Article 2, you'll see Article 3, Article 4, and for the record, I did get tested on Article 3, and the Nevada State Bar, I think first and only year that was ever tested on the bar exam. But you will see that. And so, but I do want to get back to your question, because the sad thing is if we don't adopt these, then we're falling behind times. I mean, as you heard, the UCC was established in like the 40s and 50s, and it needs to stay with modern times. You know, I mean, we're changing what should be secured interest and what could be protecting ones, like if someone was taking a loan and they had a way to secure it. We want to make sure we're addressing current technology and we're staying ahead of the game and not just having articles that are not up to date. Thank you.
Thank you so much for all of those clarifications. Did that inspire any additional questions from the committee? Looks like it didn't. So we will move to testimony in support of AB 231, starting with anybody in person in Carson City or Las Vegas. I'm not seeing anybody in Carson City coming up to the table to testify in support, and I actually can't see Las Vegas right now. I'm going to guess there's nobody there and go to the phones for testimony in support of 231.
Thank you, Chair. If you would like to testify in support of AB 231, please press star 9 to take your place in the queue. We have no callers to testify in support.
All right, then we will go to testimony in opposition to AB 231. I don't see any. Okay, there is somebody, sorry, in person in Carson City. Please go ahead whenever you're ready.
Sorry, moving a little slow after lunch. Good afternoon, committee. My name is Elise Monroy Marsala, and I'm with Bell's Case Government Affairs. I'm here today on behalf of Blockchains. Blockchain supports policy that provides uniform rules for perfecting security interests when using certain digital assets, which AB 231 seeks to do. However, while we agree with the overall policy objectives of AB 231, we have to oppose the changes made to the definition of the term money, which were added with the floor amendment, so that they appear in this first reprint. Historically, government authorized or adopted money under the Uniform Commercial Code benefits from super negotiability status. This status is critical because a business that accepts money as payment in commercial transactions must have confidence that that money it accepts is not being used as collateral for an unknown loan. Imagine for a moment that a small Nevada business selling battery technology to a manufacturer in Arizona was unsure if the money being offered as payment was subject to a lien in another state. Performing state-by-state lien search before accepting that money as payment is just not practical. Commercial activity would be severely slowed, if not halted altogether. And this is the primary reason why money enjoys super negotiability status under the UCC. The change, however, made to the definition of money turns this critical policy objective on its head. The proposed change expressly excludes any money in electronic form that otherwise meets the current definition of money in the UCC. This is problematic for traditional digital payments and emerging stablecoin payment ecosystems. Traditional digital payments like bill pay, PayPal, Venmo, and other are forms of electronic money. So with the change, all forms of electronic money would no longer enjoy super negotiability status in Nevada. Since Nevada would be the first or one of the first states to adopt this amendment, we're not sure what impact it would have on commercial transactions in Nevada. If businesses thought electronic forms of money might serve as collateral for an unknown loan. It's a big question that we don't have an answer for. Additionally, certain stablecoins like USDC represent a digital token on a blockchain, which is fully backed by $1 deposited in a major U.S. bank or custodied by fund managers such as BlackRock or highly liquid U.S. treasuries. I'm almost done, Chair. Okay. These stablecoins allow U.S. dollars to become digitized and to be moved effectively, and be moved efficiently and cost effectively across blockchain networks to the tune of billions of dollars a year in annual transactions. Stablecoins are used by millions of Americans and businesses, including those in Nevada, daily. The U.S. Congress House Financial Services Committee is currently working on bipartisan stablecoin legislation to firmly bless and appropriately regulate the electronic form of money. This type of electronic payment here today that we I'm sorry, I'm having a hard time this afternoon. I'm going to catch my breath. I'm so sorry.
We have plenty of time.
Thank you. All right. This type of electronic payment is here today, and we should think carefully about the changes to the statutes that prohibit rather than enable the use of this technology. Nevada has benefited immensely from blockchain economic development because we have been thoughtful in the type of laws and regulations that are enacted in this area. Emerging digital payment technologies are inclusive. They dramatically reduce the cost for businesses and consumers, drive economic development, and are used by a significant percentage of Nevadans. The policy objective of AB 231 can be entirely fulfilled without amending the definition of money in the UCC. Blockchains is eager and willing to work with the bill sponsor or members of this committee to work through our concerns, and we're open to bring our technical experts to the table to propose any amendments. Thank you.
Thank you so much for your testimony. I don't see any questions, so so we'll continue with any opposition testimony. I'm not seeing anybody else coming up to give in-person testimony. We will go to the phones for opposition on AB 231.
If you would like to testify in opposition to AB 231, please press star 9 to take your place in the queue. We have no callers testifying in opposition.
All right, I understand we missed a caller in support. If we could go back to support testimony on the phone really quick for AB 231.
If you would like to testify in support, please press star 9 to take your place in the queue for AB 231. I'm sorry.
Good afternoon, Madam Chair and members of the committee. This is Keith Rowley. I'm a professor of contracts and commercial law at the William S. Boyd School of Law, a Nevada Uniform Law Commissioner, and as Senator Orenshaw suggested, was an active participant in the several years-long work of the drafting committee for the 2022 amendments to UCC or to the UCC. I apologize. I did not hear all of the comments by the prior speaker from blockchains or on behalf of blockchains. I did catch a little bit of them. I'm not entirely sure that the prior speaker was aware of the revision to the bill that essentially eliminates the references to electronic money from the 2022 amendments and treats what would be electronic money as well as things that the UCC doesn't consider electronic money, but that other people might, like for instance Ether, as a controllable electronic record, as well as treating Bitcoin now as a controllable electronic record, so that they may, as Mr. Rzeski said, be passed and taken free by someone who, in good faith and for value, acquires them, not having to worry about contending claims of ownership or liens that might have been on them previously, and so that security interest in them can be taken and perfected by not just other on-chain lenders and participants, but by traditional lenders as well, who are looking for a way to perfect the security interest in an asset that at the moment, at least in the form of Bitcoin, is unperfectible. So there are a number of reasons to support the amendments. The concern about affecting the ability to use stablecoin or other types of cryptocurrencies really addresses the subject matter of a completely different bill, which was the Uniform Regulation of Virtual Currency Business Act, that a form of which Senator Neal revived and has gotten through committee. I'm not sure exactly what its status is now, SB 333. The UCC does not try to regulate what is and isn't used for private payment purposes. It doesn't regulate the day-to-day operations of the payment system, except to the extent that it has rules governing check collection and the negotiability of certain types of notes and other instruments. But even that, as Mr. Rzeski said, is the negotiability is being opened up to include electronic equivalents to paper instruments and paper records that were not previously capable of being negotiated under the rules in the UCC or being taken free of claims by competing parties prior in the chain of title from the person from whom the person who acquired them in good faith and for value took them. So I am, as Senator Orenshaw and or Assemblywoman Bacchus suggested, I am available to meet with the committee or any members of the committee or to communicate with you by email if there's a subsequent working session, and I'm happy to take any questions if that's even practical with me on the phone like this. I apologize. It was just a scheduling conflict that I could not avoid.
No problem, Professor Rowley. Thank you for joining us via phone. Are there any questions? I'm not seeing any questions, so we certainly appreciate your support testimony. And I think that we have already done support now and opposition. We'll move to neutral testimony on AB 231. I don't see anybody coming to the table in Carson City or Las Vegas, so we'll go to the phone for neutral testimony on AB 231.
If you would like to testify in neutral for AB 231, please press *9 to take your place in the queue. We have no callers testifying in neutral.
All right, I'll invite our sponsor back up to give any closing remarks or clarifications whenever you're ready.
Thank you so much, Shay Backus. For the record, I'm going to just kind of say something broadly, and I'll probably turn it over to Mr. Orzeski just to cover on some of the opposition inquiry from blockchain. But one thing is I would have loved not to have utilized the amendment. I would have been happy with it being the uniform law, but because of just some concerns over some of the original language, the amendment was necessary. But I wanted to assure people, when we're looking at whether or not Bitcoin is included or not, Bitcoin is included. The terminology is the controllable electronic record, and that is definitely carried throughout a lot of AB 231, which the updated articles would address. And with that, I will turn it over to Mr. Orzeski.
Thank you. And I'll just briefly address the representative from Blockchain's concern. She was absolutely correct that money is super negotiable, has a special status under the UCC. But what this bill does is it gives that same super negotiability status to controllable electronic records. They're a different category subject to the same rules. And the reason that they're categorized differently is that the rules that have been in existence for money since the 1940s didn't work well for intangible assets. So it was necessary to categorize them as this new blanket term. Came up with a controllable electronic record, which builds on previous UCC definitions of record and electronic record, and differentiates them by the type of control as defined in the bill as to how one person can have control of the electronic asset and transfer it to another and prevent others from using it. So I think we're all on the same page about the benefits for controllable electronic records. The amendments that were introduced in the House were to address a slightly different concern that arose in a few states about electronic money, something called central bank digital currency, which is not a controllable electronic record, but something backed by a government. It was put in there to allow Nevada businesses or businesses in any state that adopts these to do business with foreign countries that have already with businesses in foreign countries that have adopted these currencies. There is not one in the United States, and there is a lot of political opposition to the idea of having one in the United States. And so to eliminate that concern was why the amendment was added in the House to remove references to electronic money. But we've retained all of the negotiability benefits, the same ones that apply to money for use for the benefit of controllable electronic records when used under the UCC.
All right. I think we do have one more question from Senator Wynn.
So I think you clarified, but just to make it very clear, because I heard that opposition testimony, and it's my understanding, and is it like common, is this a common term that's used to describe, I guess, cryptocurrency, this controllable electronic record?
It was coined by the drafting committee that developed these amendments to the UCC, and it was created, whenever we draft, we try not to use terms like blockchain or cryptocurrency because they can very quickly become outdated by further advances in technology. So we try to define things functionally by how they work. And so that was where the definition of control and controllable electronic record came from. They're also, unlike money, they're not limited in their various uses. They're not only a medium of exchange. You can have controllable electronic records that embody property rights or payment rights and can be used as rights in art, in the case of a non-fungible token. So we didn't want to limit it to the rules for money, which only apply to mediums of exchange. So that was the reason for categorizing them separately, not to in any way disadvantage their use relative to money.
Thank you.
All right. Any other questions? I don't see any further questions. Appreciate you being here and presenting this bill to us. And that will conclude the hearing on AB 231. I'll close the hearing and move now to public comment. If there's anybody wishing to give public comment in person, now is the time to come forward, but I don't see anybody in person, so we will go to the phones for public comment. Remember, you'll each have 2 minutes to speak.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Tanya Brown, TONJA-BROWN, Advocates for the Inmates and the Innocent. Thank you, Madam Chair and members of the committee, for hearing us today. On behalf of Advocates for the Inmates and the Innocent and Nevada Strong Battleborn, we would like for you to consider our proposed amendment, an ombudsman, to AB 452 that's going to be coming up before you. We want to say that we had every intention of putting our proposed amendment in over on the Assembly Judiciary. However, the committee had an unagendized work session on AB 42, so we were unable to get it in at that time. So we are asking for you to consider this proposed amendment. And I want to provide you with a brief history as to why having an ombudsman is much needed. When the Nevada Offender Information Tracking System, which is NOTICE, was installed in 2007, a computer glitch happened and placed false felony charges in inmates' files. The NDOC had hidden this information for years until I discovered it during the deposition of the former NDOC warden and assistant director of NDOC. As a result of the discovery, in 2012, NDOC was asked about the false felony charges. NDOC established that 10% of the prison population had false felony charges in their NOTICE files. Everyone with a life sentence was affected by it. They also stated that they didn't know how to fix it, but when the inmate would come up for parole, they would remove the false charges. Computer glitch would come back and reappear in an inmate's file after being removed. The former Assemblyman Al Kramer had received a letter from an inmate in Union State Prison about the false charges in his file, so he came to see me to discuss it. I still continue over the years to get calls from inmates and their families about the false charges, and they don't understand why they're in their files. Some of the inmates, while still incarcerated, had expired a sentence and moved on to their next sentence. However, the glitch showed that the expired sentence has now a brand new sentence. Some of those who had false felony charges had previously been incarcerated, had their sentence expire, and then they had been paroled. When they would return back to prison, and that expired sentence would reappear in their NOTICE file with a brand new charge. These are the reasons why NDOC needs to have an ombudsman to check for accuracy and correct the NOTICE file if needed and make the proper notification to the parole board commissioners and to the pardons board. For these reasons, we are asking you to support or possibly sponsor a conceptual amendment to Assembly Bill 452. We have previously emailed all of you a copy of our proposed amendment and to the Senate Judiciary, and please consider our proposed amendment. Thank you.
Anne Marie Grant, Advocates for the Inmates and the Innocent, ANNEMARIEGRANT. I'd like to ask that you support our amendment to AB 49, adding language for a petition to establish factual innocence posthumously. Currently, we are only aware of one case that this may affect, but that doesn't mean there's others in the future that won't be identified. I'd like to talk about the Washoe County CIC Conviction Integrity Committee and use it to exemplify why a petition to establish factual innocence posthumously is needed and is what is best if we are seeking true reform of our criminal legal system. I requested data from the CIC unit in June of 2020 and again in 2022, and there have been only 2 cases submitted since its inception in 2018. One received a fair review. The other case of Nolan Klein did not receive a fair review. The only difference between the two is one was not claiming prosecutorial misconduct, while Mr. Klein's case claimed the prosecutor withheld exculpatory evidence. The first case, all of the documents, filings, and pleadings were reviewed. It is clear from the 2019 letter from DDA Noble to Ms. Brown regarding her so-called review of Mr. Klein's case that all DDA Noble did was read previous court orders when the CIC committee should be looking at the filings of the defendant, the newly discovered evidence that was submitted to them, and not simply rehashing old court orders. DDA Noble stated the CIC cannot offer a more thorough assessment of your claim than the 12 citizens that served on the jury. By the way, that was a jury that did not get to see all of the exculpatory evidence that was found in 2009, and that jury had been deadlocked for 2 days. If that is her assessment about Mr. Klein's case, will she maintain that position for every person convicted by a jury who maintains their innocence and asks for a review? There is no true remedy for someone who has died in prison that was wrongfully convicted in Nevada. Your job as legislatures is to create those remedies. Our amendment to AB 49, adding language for a petition to establish factual innocence posthumously, is that remedy. Thank you.
Madam Chair, members of the committee, this is Keith, Keith Rowley, Rowley. Realized I didn't do that the first time. Sorry, there's one more thing I wanted to add. I know there was a question about the number of states that have enacted the amendments, the 2022 amendments to the UCC. That is, 2 at the moment, North Dakota and New Mexico. 3 other states, and if this was already said, I apologize for being repetitive, but I didn't hear it because I was having intermittent audio. Colorado, Indiana, Washington State, the bill has passed both chambers and is either sitting on the governor's desk or is in the process of being delivered to the governor. And 2 or 3 additional states, I don't want to jinx, look like they're very close to reconciling versions between the 2 chambers. So if there was any concern that Nevada would be getting too far out ahead, I hope that that would be assuaged by the fact that a number of other states are acting, and a number of additional states have shorter legislative sessions in the spring because they meet every year, or some of them meet year-round, including California, or off and on anyway, and have bills pending. Just wanted to get that additional tidbit on the record in case it wasn't. Thank you for your time.
Includes all callers for public comment.
All right, that brings us to the end of our meeting today. Tomorrow at 1 p.m. Is the unveiling and dedication ceremony of the new firefighters memorial out on the plaza. So we will not be having Judiciary tomorrow in order to allow everybody to attend that very special and important event. We are still working on the schedule. I don't think that we will have a meeting. I don't know if we will have a meeting on Friday. Stay tuned. For now, we are adjourned.